My name's Olivia McGovern. I'm an attorney with the firm Alshire & Winder, and I'm here with my colleagues.
Hi, good morning, everyone. Isaac Young. I'm also with Alshire & Winder.
I'm Matt Cohen. I'm a partner at Alshire & Winder.
So this is an overview of what we're going to be discussing today. We'll go over the Brown Act, briefly parliamentary procedure, ethics, and general questions at the end. Although if you do have questions on, a specific issue that's on a slide, feel free to ask.
Oh, and before we further address a couple of things. Ordinarily for meetings like this, we would do roll call, etc. However, I will note that this is a special meeting. This meeting was called where it is for the city council as well as all of the commissions, and we had everybody sign in that could be in attendance. There's not necessarily going to be a quorum for all of the commissions, and this is going to be a recorded meeting, so essentially it's a presentation and a training. And so for that purpose, we made sure that the meeting was agendized and that everybody had an opportunity to step in and sign in. And for that purpose, you do see that it's here on the agenda, but we will not be taking a specific roll call. We'll be asking to address every particular commission one by one. Nor will I be asking for every specific city council person or asking the city clerk to take note of that. That will be captured here on the training sign-in sheet. And so if you haven't signed in, please, by the time the end of the meeting occurs, sign in so that way we can capture that. Also, we would ordinarily do the Pledge of Allegiance. As you can see, there is no flag here. It is outside. So for that purpose, we can still do a Pledge of Allegiance, but note that there is no flag in here. So if you all would like to stand and do the Pledge of Allegiance, please rise.
Yeah, we need that. Imaginary.
We can face that way. Right hand over your heart. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, please be seated. All right, and now we will go ahead and continue with our Brown Act and ethics training. Thank you, Olivia.
Okay. So the Brown Act as a law in general is aimed at prohibiting non-publicized discussions about city business. It's making sure that city business is conducted in the open and available to the public, allowing them to participate. So a meeting is a gathering of a majority of the members of a legislative body that hears, discusses, or deliberates upon any item that's within the subject matter of your commission or city council. And given the personnel matters, and for personnel matters, employees must get 24 hours written notice of the right to have their charges heard in open session as opposed to closed session if they so wish. And after closed session, there must be a convening an open session to let everyone know, we're returning from closed session and make required disclosures. You still need to agendize a closed session. It'll be briefly described and it'll be verbally announced before you go into closed session and after you return. And disclosure of anything discussed in closed session is illegal. Everything that's said in closed session is supposed to remain in closed session. Per the statute, there are certain votes where there needs to be a public report of any action taken in closed session and the vote or abstention of every member present. So they're very specific things such as approval of an agreement concluding real property negotiations, approval to legal counsel to take action, approval of a final settlement, disposition as to a tort claim, action taken to appoint, employ, dismiss, or accept the resignation of a public employee, approval of an agreement after labor negotiations have been concluded, and certain pension fund transactions. There's also a new law called SB 707, which takes effect on July 1st. And a lot of it has to do with post-COVID formalizing some of the things that took place. So by July 1st, the city council needs to provide hybrid meetings, so an in-person plus a two-way telephonic or Zoom participation, and a call-in option and captioning if available. They also need to adopt a policy regarding procedures for restoring service in a disruption. So if a disruption prevents the meeting from continuing, they need to publicly announce that, take a recess, and if it can't be restored within 1 hour, they must conduct a roll call vote, confirming that good faith efforts were made and that it's in the best finding in the best public interest that they need to continue the meeting. There's also a new requirement about council members with a disability may participate remotely as a reasonable accommodation. And council members who participate remotely must have the legal basis for their remote participation recorded in any meeting minutes. A few more requirements of this new law: before any commissions or boards want to meet remotely, the city council must formally authorize this. And it's the same with having a two-way like Zoom or call-in option available. And each commission every 6 months needs to expressly reauthorize their desire to continue meeting remotely. And members of the public attending these meetings remotely must be able to provide public comment in the same way that they're attending remotely. And remote speakers must receive the same time that in-person speakers receive. Next, we're not going to go through everything, but all commissions and councils should follow a general parliamentary procedure. And there's just certain words and phrases that you use when you're proposing a motion or amending a motion. So these are some of the phrases that you use. I move to amend the motion by doing X, Y, and Z. I move that we introduce X, Y, and Z. So those are some samples.
By the way, I'll also add that this PowerPoint presentation we will be sharing. So these parliamentary procedures that Olivia just had up are something that we intend to share with the public. So it's not something you have to have memorized.
Okay, also this is more for commissions and boards, but when they make recommendations to the city council, the chair of said commission or board can work with city staff in order to finalize that recommendation, draft some correspondence to the city council and mayor with their recommendation, and then once it's left the board or commission, it's in the hands of the mayor and council to decide on next steps. During a commission meeting, when a commissioner would like to add an item to an agenda, they should do so via motion during that meeting. That's the best way to add something to an agenda. The chair of the board or commission can then facilitate a discussion, and you can vote to add it to the next agenda. That's it for the basics on the Brown Act and parliamentary procedure. Are there any questions so far? Yes.
You had mentioned emergency meeting.
Yes.
I'm just wondering, who will determine the need for the emergency meeting? Would it be the mayor exclusively? Would it be a council member requesting it? Or a city manager? I mean, are there steps that have to be taken to determine the need of the emergency versus waiting for the following meeting to occur?
That's a good question. So what generally happens is when information is given to either the city manager or oftentimes the city attorney's office, that information will be presented to the city council. Like if there's a case, for instance, and a litigated matter, and that matter, I'm just using this as an example, has a settlement that is pending, and there's a trial date that's looming. It's within the next week, and they determined that the settlement could be reached right before the trial deadline, then that could be an emergency based on that statute, but it has to be presented to the council, and the council has to decide whether they want to move forward with that potential settlement or not. And so in those particular circumstances, the council has to make a decision whether they want to move forward with it, and then there's two potential ways that they can move forward. One is they can, by that 2/3 majority vote requirement of all members of the body, make the decision to have it added to the agenda that night. Or if there's only a quorum of the members, meaning there's only like 3 members present, then they have to decide whether they want to move forward with the item, but it has to be unanimous in that particular circumstance. So it really depends, but that presentation has to come from somebody else, like the city manager's office or someone like the city attorney's office, to inform the council, and it has to be subsequently after the items were agendized already, because the members of the public need to know that there was an item on the agenda that now is suddenly going to be discussed, and they need to have the opportunity, because it's supposed to be a transparency thing, but the reason why it wasn't transparent at the time is because it came after the time the agenda was posted. Hopefully that makes sense.
Thank you.
Thanks.
Yes.
I have a question. Your agenda, is it a legal documentation?
It can be. And what I mean by that is the agenda is based on the transparency requirements anyway. And so you're legally required to have an agenda posting. And it can be a legal document in the sense that it can provide evidence as to what happened at a particular meeting. So, yes.
So I have another question. Is there any time that you can actually go back and the entire body vote against our agenda and decide to change the wording of everything and create a new one? Is that legal, or can you do that?
I don't know about changing the words entirely of an agenda.
Yes, absolutely.
That I'd be interested in what you mean by that. Maybe I could discuss that later with you. I'm curious.
I think it comes down to notice, right? The agenda is not a legal document in the sense that it's a contract or anything. It's a official record of the city,
Yes.
and it's required for notice. So if you're going to change the wording of an agenda, do you have sufficient time to provide notice in that circumstance? If it's more than 72 hours, you could probably change the wording. If not, then you have to look at whether there are relevant exceptions that could apply. So I think it would depend on the factual circumstance, but the end result is we typically don't want to surprise the public with new information that they haven't had time to to absorb and react to, and so we don't want to change official agendas within the 72 hour window, 24 hour window. So, yeah.
Okay. So next we're going into the ethics rules, and just warning you ahead of time, some of them are complicated, but at the end of the day, the best thing to do is, if you're concerned about something, come ask us, come ask our office if you're concerned, because these rules are complicated and difficult to understand. But at the end of the day, they're all about preserving the public's trust in us and making sure that we're serving their best interest and not personal interests. So we're going to go through 4 groups of laws, one related to personal financial gain, another related to personal advantages and perks, transparency, and fair process. So public servants should not benefit from their positions. That's the baseline. And all of these laws are governed by the Political Reform Act, which regulates the actions of public officials. And essentially the bottom line is, no public official shall make, participate in making, or in any way use his or her official position to influence a government decision in which they know or have reason to know that they have a financial interest. And we'll go through what the different financial interests are. And you must refrain from participating in a governmental decision when it's reasonably foreseeable that the decision will have a material financial effect on your financial interest that's distinguishable from that of the public generally. And certain people, like council members, the mayor, planning commissions, have to file what's called a Form 700 when you assume office annually, and when you leave office, and in that form you declare certain economic interests that you and your spouse have. So examples of laws within this first category are bribery and related crimes, financial interest disqualification, and revolving door restrictions when you leave your public office. So bribery is conferring a benefit on a public official to influence that person's vote, opinion, or action or inaction, and the penalties are obviously very serious: loss of your office, prison time, fines, attorney's fees, and fines whether or not the bribe was actually even received. Next is disqualification based on financial interests. So you have to abstain or disqualify yourself when you have a certain financial interest, and it has to be financial. It has to have the ability to make you money or cost you money. So it could be gaining money or losing money. These are different ways that economic interests can arise. It can be from business, it can be from income that you or your spouse receive, it can be from gifts, and it could also be from real property. So there are certain kinds of interests that are disqualifying. So first is the $500 rule. So if you receive, or if you're promised to receive, or if your spouse or child is promised to receive, or if you're going to get a personal loan in the amount of $500, you cannot participate in a decision regarding whoever gave you that money. So for example, if a council member's spouse worked for a local engineering firm and earned money from that firm, and then the engineering firm submits a proposal to do work for the city, since the spouse has earned more than $500 in the past year from that engineering firm, the council member who is married to that person should not participate in the decision. There's also a $2,000 rule, where if you have an investment in a business entity or in real property that's worth $2,000, you should not participate in any decisions regarding that business. The real property interests are a little bit more complicated, but if you live 500 feet or less from a location where something is being proposed by the city, there's presumed to be a conflict of interest that can be rebutted by clear and convincing evidence, but just because it's so close, it's presumed to have an effect. So, for example, if you live in a building and the city is going to vote to approve a new building that's within 500 feet or where you live, because that's going to affect your property value, you should not participate in that vote. Once you get past 500 feet, the middle ground of 500 to 1,000 feet is a little more complicated, where different factors come into play. So that would be something where you would come to our office if that was the situation. Over 1,000 feet, there is presumed not to be a conflict. So we talked about these gifts of $50 and, there's also a rule that you cannot accept any gifts worth more than $630 from a single source within a calendar year. So even if it's a lump sum of $630 or added up, you've received smaller amounts that add up to $630 from the same source, you cannot do that. And if you do receive a gift that's worth more than $50, you should report that if you're reporting on your Form 700. And this $630 amount is updated every 2 years to adjust for inflation. So this $630 is the amount through the end of 2026. They haven't yet announced what the 2027, 2028 dollar limit amount is. There are exceptions to participating in a decision when you may have a conflict. They're the public generally exception and the legally required participation. So public generally exception, when the effect that it has on you would be the same as the general public. So an example would be the city considering a new sales tax. That's going to affect everyone who lives in the city. So your position is not different from the public at all. It's not unique to you. If the council were to vote to increase water rates for residential use, that would be another example of everyone is affected by that and it's not unique to you. This is really rare and it wouldn't come up, but if all members of a body have a conflict and there's no quorum, that's a problem because the rule of necessity says that a public body has to act on a matter before it. So if there were a conflict, there would be drawing lots where it would essentially be at random. They would pick people to participate because they need a quorum. But again, this is very rare and unlikely to happen. But those are the two exceptions to conflicts. And essentially the test that we have to go through when we're considering these types of conflicts is it reasonably foreseeable that the decision will have a financial effect on the public officials' financial interests? Will that reasonably foreseeable effect be material? You ask whether it's distinguishable or not from the general public, and that's what you have to consider. So if a conflict does exist, like I mentioned that example with the council member whose spouse works for an engineering company that's going to submit a proposal to the city, you do not participate in the discussion, you do not discuss it, you do not try to influence your colleagues to vote a certain way on it, you disclose the conflict and you disqualify yourself. Usually you stand up during the council meeting, you give a brief reason why you are disqualifying yourself, and you leave the room, and you don't vote, and you don't discuss, and because you've left, you also don't count towards a quorum for that meeting. The penalties for violating these rules that we just discussed vary, but a decision could be invalidated if you have a conflict and end up voting on it. You could lose the office. There could be a misdemeanor, civil and criminal fines, personal and political embarrassment. And this is an extreme example, but in the city of Los Angeles, we had a council member Jose Huizar, who represented the downtown area, and he pled guilty to federal criminal charges for using his position to enrich himself. He accepted bribes, gambling chips, private flights, luxury hotels, and used that to give benefits to developers who were building in his district. He's in prison serving a 13-year sentence and had to pay hundreds of thousands of dollars in fines and restitution. So that's an extreme example, but it just goes to show how serious these crimes are. So another conflict of interest is when you are making public contracts and you have an interest. So a financial interest would be if you're the landlord or the tenant of a party for the contract, if you're an attorney or agent of one of the contracting parties, if you're supplying goods or services for the contract, or you're an officer or employee of a nonprofit that's a contracting employee. And it's the potential, if you participate when you're not supposed to, that the contract could be void. So, like I said, it would be void and unenforceable. The public official would be subject to civil and criminal penalties, and they may even have to refund money if they received money from that contract. There's an example from the 80s in the city of Albany in the Bay Area where a council member owned property that he sold to a developer, and then that developer was just a pass-through to then sell it to the city. And the council member did try to ask the city attorney there for advice. He recused himself from some votes, but the city ended up purchasing this property that he originally owned. And eventually there was a lawsuit, and the California Supreme Court ruled that it was an illegal contract. He should have never been selling his land to the city, and he had to pay the city a lot of money. And it just goes to show you should not be involved at all in receiving money for your property when you sell it, if it gets sold to the city. Even if you use an intermediary like he tried to do with the developer, at the end of the day, that was just a pass-through. This is a new category of rules, but there are certain future employment prohibitions that prohibit a revolving door, essentially. It is reserved for elected officials and top managers, but it's essentially a ban for a year after they leave their agency from essentially lobbying their former colleagues. There's another thing called feathering your nest prohibition, where if you have a prospective future employer, you shouldn't be doing things in your current job to make things, look attractive for them or try to get hired by them, essentially. Okay, we're gonna move to a new section of rules, perks. One second. So you shouldn't receive special benefits just by virtue of your position. So there's gifts, perks that others offer you, and then there's the use of public resources, essentially gifts that you give yourself by virtue of having your position. So it's prohibited to use public resources for your own personal benefit. Resources include city funds, city equipment, staff time, supplies, and there are some limitations on when you seek reimbursement from the city. It must be with the city policy, there needs to be clear documentation, and any mistakes must be corrected right away, and you're not allowed to use expenses for your family. Perks that others offer, we talked about this, you have to report any gifts that are $500 and up. There's a limit of receiving $630 of gifts a year. There are some exceptions for certain types of official travel related to official business. But gifts aren't always obvious. It's not just tickets, it could be meals, food and drink, entertainment tickets, and gifts to your family. And if you have a problem with a gift, you can always give it back to the person who gave it to you within 30 days. If it's something like a ticket, you can reimburse the person for the fair market value of the ticket also within 30 days. And again, if you have questions about a gift, you can always ask us. Gifts also include gifts to your family, and they've expanded the definition of immediate family. It includes your spouse, registered domestic partner, a minor child who you claim as a dependent, and also a child who's aged 18 to 23, is in school, but lives with you when they're not in school and doesn't provide for themselves, essentially. So tickets, like I said, are for shows, events, performances, and free tickets from the city are subject to those prohibitions I described and applicable to report on your Form 700. However, if the city has a policy regarding tickets, they're not considered free if you report them on a certain form and you report them as income on your taxes, or you're there in a ceremonial role where you're speaking or doing a ribbon cutting, that's okay. Or if you choose to return or donate your ticket to a nonprofit without taking a tax deduction, or if it meets an adopted gift policy that the city has. Again, the penalties for violating these are serious. They can be up to $5,000 per violation, your attorney's fees, and other people's attorney's fees. Okay, the next group are transparency laws. We already went over the Brown Act, but there's also the Public Records Act, which allows public inspection of records. So a public record is any writing containing information related to the conduct of the people's business retained by the public agency, all agendas, all materials at meetings, all records, emails, hard copies that are prepared, owned, used, or retained by the city. There are certain exceptions, such as documents that are attorney-client privilege, that are related to pending litigation, that have personal private information on them. Those can be redacted and withheld. However, there's been recent case law that shows if a public employee is conducting government business on their city phone or on their, if you're using a personal account like your personal cell phone to conduct city business, those records could potentially be disclosable. And you would have to submit an affidavit saying you looked through your personal cell phone, you disclosed any government-related work that you were doing on it, and it could be responsive and it could be released in response to a Public Records Act request.
I should add that also includes your personal email address as well. So if you are using your personal email for city-related business and your personal cell phone for city-related business, they also can be subject to the Public Records Act. So just something to keep in mind.
What about your social media accounts?
Yes.
Yes. Also.
Yeah, you wanna keep everything separate, so like, separate accounts, separate email accounts, because anything you do on your personal, if you're using it for official business, then someone has a right to go and ask for all your personal email, and you don't want that, so.
Yeah, and we deal with these types of requests all the time. So within 10 days of us receiving a request, we have to tell the person we either do or do not have records that are responsive. And then within 14 days, we usually disclose. And if there's a voluminous amount of records, we set up a schedule with the person where normally like every 2 weeks we'll release emails or any documents that are responsive to their request.
You had a question? I'm sorry.
That includes blind copying, if I'm correct, under FOIA. Is that like one of the, when it comes to email?
FOIA is an overlap. FOIA is actually the federal equivalent of the statute, but yes, it does include blind copying. So if you're using your personal email, then yes, it would still be included if it was a blind copy of that email. So it would still capture it, and so it would still be subject to the Public Records Act disclosure system. It's just like your text messages if somehow somebody got included. And the same thing with virtually any other form of media. You would still have to produce the record if it's responsive, provided that there's not an exception or an exemption to the Public Records Act.
This last group have to do with fair process laws. So the public expects you to be impartial when you're considering their items. So this has to do with open public hearing. This is probably more common with like a planning commission or certain development items that come to a city council. But there must be an open public hearing, a staff report, an opportunity to ask questions of the staff. The applicant has an opportunity to be heard and present. There's also an opportunity for opposition and rebuttal. If necessary, there could be a closed public hearing. But here are just a few examples of reasons where, situations where there was not a fair process. So there was a case where an applicant wanted to build a residential development, which went before the Planning Commission. One of the commissioners authored an article attacking the proposed development before the hearing, and the project was denied, and it went on appeal, and the court decided it needed to be held before an impartial panel. So because this commissioner went and publicized his opinion before hearing what the staff had to say, before hearing what the applicant had to say, it was not a fair hearing for the applicant, and so they had to hear it again. Another situation in Hermosa Beach, an applicant wanted to demolish a duplex and build a condo. Some of the neighbors challenged it because the condo would block their view, and there was a council member who refused to recuse himself even though he lived 1 block away, and the new development would also impact his view. And so that was a violation of a fair hearing because he wouldn't recuse himself despite having an interest in the matter. So the lesson there is don't advertise your viewpoint ahead of time, and don't discuss it before a meeting. And if you do have a disqualifying interest, you know, recuse yourself if it's that. But more so of the don't advertise it, you know, don't publish an article like that person did before you hear what all sides have to say about the issue. And generally best practices, you know, fairness and merit-based decision-making, avoid commenting or publicizing your opinion before the public hearing. And again, these laws are the minimum standards for ethical behavior. And if you have questions about any of them, ask and ask early. It's your choice how high you want to set your sights above the minimum requirements for disqualifying yourself from certain votes. And at the end of the day, you want to think about what would the public feel best about, what would inspire public confidence in your actions, what would you want to or not read about yourself in the newspaper, and how you want to be remembered as a public official who's serving your community. And that's the end, actually, of our presentation. So if anyone has questions.
Excuse me. Good morning. We're just wondering if we can get a copy
Yes.
of your, whatever you had.
Yes.
Wash your hands.
Thank you. The form that you were reading from.
Yes.
Yes.
Thank you.
So this is all very dry stuff, and I'm really sorry. But I guess the take home is, first of all, you're not expected to remember all these details. We'll give you the presentation. The second thing is, we're here. So if you have questions, this is really just to give you a primer on the issues that could come up in day-to-day, and then we're here to answer any questions you might have as they come up on a fact-specific basis.
I have a question.
Yes, ma'am.
My question is, if, a commissioner, can a commissioner, campaign for a candidate that's running for office, a commissioner? Can a commissioner be out campaigning with signs and all that?
As their personal capacity or as a commissioner?
Well,
personal
it
capacity,
depends.
there's free speech issues that would come into play, so yes. But if you're using your official position in your title, that would be a question. I would probably avoid using your official position and title in the campaign. But absolutely, free speech applies, and you can utilize that in public forum. So, yes, sir.
It'd be a good idea whenever they want an opinion to get it in writing from the attorney.
Absolutely, yes, yeah, because you have it in writing, it's much better than just a hallway conversation. And I always say that, I always say, listen, I can give you the offhand, off the cuff answer, but at the end of the day, you're more protected if you have something in writing, because that's, our job is to protect you, and our job is to make sure that you don't get into trouble. Your job is to kind of use, you know, the bells that might go off in your head and say, oh, is this a situation that could present a problem for me, or do I have a question? Then just ask, that's all. And you know, one of the take homes I think of today is recusal is always an option. If you're not involved, nobody can blame you for it, right? And the other thing is, you know, with gifts, which get complicated, if you don't want to report it, or if it's a problem, just give it back, you know, or don't accept it. Yes, ma'am.
When, during the council meeting, you have your mayor and your council, and they voting on a particular item, and one of the council or two of the council say that they recuse themselves. They're supposed to give us an explanation of why they recuse themselves.
They should give a general, you know, reason. They don't have to go into every specific.
But they should.
They should say, you know, I have a conflict of interest or something like that, and then they're recusing themselves. Yes, sir. Sorry, I've been taking.
Early on, you spoke about Zoom meetings and attendance and whatnot. You had mentioned that two things. You said something about the policy should be updated every 6 months, or?
For advisor, so commissions and boards that want to meet remotely, first, the city council has to authorize that. And then the board or commission itself, every 6 months, has to decide they want to continue meeting virtually.
So with that being said, if the council were to authorize that, would they need to do it for all committees, or just each committee individually?
They would have to say which committees they're doing it. Usually planning commissions absolutely covered, and then to the extent there's other commissions, that's up to the purview of the city council.
Thank you.
Yes, ma'am.
Hi, I have a question. I know that for council meetings, when a council member abstains, they are required to provide on the floor the verbal reason why. Does that also apply to our legislative boards and commissions? If we're voting on something, let's say for like the beautification committee, and someone abstains, should they state why they are doing so for the record?
I think that's appropriate. I mean, sunshine's always the best policy, right?
Right.
Because it's the best disinfectant, right? We say, so like, just say, I have a property interest nearby, or I have a personal financial interest, and therefore I need to, like, we don't need to get into all the sort of details, right? But we just give a general overview of the basis for the refusal.
Thank you.
Do we have any other questions?
Yeah, I know this is dry stuff. I think at the end of the day, the idea is just to get it in front of you so you have an idea of what the rules are, and then as questions come up, specific fact patterns, we're here to help. That's what we're here for. Yes, ma'am.
What if you get a gift and you don't know where it came from?
That is a great question.
So what do you do? So do you give it to nonprofit or give it away, or?
You can donate it, or well, if you donate it, then that creates a problem too.
Yeah,
I
well,
mean,
where it come-
depends on what the gift is. If it's perishable, there's certain issues that can come up.
It also depends on the value.
Yeah, the
Because if
value.
it's under $50, then you don't have to report it. But if it's over $50, you should report it if you're keeping it. But you can still report it. Your problem is you don't know where it came from, so it will be really weird to report. But
Find the answer, let me know.
you might have to do some digging.
Yeah, who's giving you all these anonymous gifts? You have some benefactor.
I did, I think a lot.
Yes, ma'am.
My question is, you guys talk about personal gain, but you talk about personal gain for financial.
What about personal gain for other things?
Exactly.
Like, are you talking about like an increase in stature in the community? I get.
Well, okay, let's say, let's say that.
I think the question would be, would that result in a financial impact? I mean, I always use the small test, right? Objective standard. Could someone question your impartiality in the matter?
Okay, let's say.
And that's a little different than conflicts of interest. But if someone has, you wanna hold yourself above, beyond repute, right? And so if someone could question your impartiality in the matter, then you have a decision to make as to whether or not you wanna recuse yourself from this issue. But, I mean, it's not really that's a more fuzzy standard. It's not like conflicts of interest which result in, could result in criminal prosecution. I guess the question is like, it's a fact-specific pattern, right? So if someone questions your impartiality, you think that you're vulnerable to that, you could recuse yourself. I mean, if you needed to,
If
but you're not
decent,
required.
you gotta be decent.
You still have an option and an opportunity as a leader in the community to express your opinion and to take a position on something. So it's a little,
A little hazy.
yeah.
Okay.
I didn't really answer the question.
You didn't explain it right.
He didn't want to give the it depends lawyer.
Yes. Well, it's fact specific, right? So I'm trying to think of some examples of like.
Yeah, but a good rule of thumb, if you don't feel in your gut that it's appropriate or you feel it's a concern that it may jeopardize your trust within the community,
Absolutely.
should just sustain.
Absolutely.
Yeah.
I give these
Yeah.
presentations called ethical decision making in the workplace.
Well,
And there's this theory about the bell, the book, and the candle, right? And the bell is the alarm that goes off in your head when something just doesn't sound right. And the book is the what does the law say? What does the rules say? What do your
Right.
community norms say? What are your standards with your religious institutions? What do they say how you should behave yourself, right? And then the candle is your own ethics, like what do you use to light your way, right? And so the idea is, a lot of this is fuzzy and it's fact specific, but ultimately it's all up to your kind of decision-making capabilities, and come seek help. We can advise you.
Yes.
If you know or you suspect one of your colleagues that's doing something illegal and you know it's illegal, do you have the responsibility to report them?
Responsibility is a good word.
I want to ask you questions after this. I want to ask you.
You don't have an obligation to report them, but you certainly should be having some conversations. I would be, if you were on a commission or if you were on the council, the least you should be doing is giving a phone call and asking one of us, hey, so-and-so is doing this. Should they be doing that? Is this ethical? Does this violate the law? Because the first thing we would do is start working with the city manager's office or whoever to start figuring out whether this is proper, and then figuring out what the proper avenue to get the issue resolved is. Because maybe they haven't taken the action yet, right? And if they haven't taken the action yet, maybe we can stop it before it even starts. And that, it would be a lot better for that individual and perhaps the city than it would be for us to just stand idly by, watch it happen, and then later on start pointing fingers. Because that's the last thing we want to do. What we want ultimately is to make sure that the city's on track and that the community is having its goals accomplished, and we're not getting that if people are violating the law ultimately.
I often tell people, we're not the police, we're not the prosecutors, we're here to protect you all, and we're here to protect the city, right? And so, we're here to advise you on what the law is and how to stay out of trouble. That's all we want. We don't want, we're not out to get you or gotcha or anything like that. We just want to make sure people have the right information in their hands so they can make good decisions.
So wait a minute, for clarity, because you guys, I've heard a whole bunch of stuff.
Yes.
So for clarity, excuse me, for clarity, so you're saying go to that person and talk to them, and then,
No.
okay?
I'm saying talk to us if there's
Talk
a
to us
question
if
you
you have a
have.
Okay, so,
And then,
okay.
Yeah, you don't want to create problems. I mean, if
Okay, okay.
there might be mitigating circumstances, there might be exceptions. It's good to but if you have concerns and something's raising alarms in your head, absolutely talk to
Okay,
us.
okay,
Yeah.
thank you.
yes ma'am.
I have a clarifying or procedural question.
So do you guys have a free advice line? Or should commissioners contact the city manager's office if they have questions?
They can email the city manager's office, they can email us directly, or, yeah, we would be happy to have a free advice pass, we could host one, that would be no issue. We would just have to ask the city council if we could set one up. That would be no big deal.
And the only reason I ask is because some commissioners do have questions.
Yeah.
And just procedurally, maybe the council should, develop a procedure, so that way, there's some order to it.
Yeah, and a lot of times what we'll do is we'll have an attorney assigned to each commission. They might not be present in all the meetings depending on whether or not it's required or it's really at that level. But they'll at least have a go-to contact that they say, hey, listen, this is the person I should reach out to for questions. And we might not know the answer, and we might farm it out to another person. We got 70 attorneys, that know different specialties.
But we
and
want that
different
free,
things.
we want that free housing.
Yes, ma'am.
If that happens, I will ask, and if it happens, then I will discuss it further.
Okay.
But I have no issue with hosting a free advice class, that would be no problem.
She's talking about a call.
Oh, yeah, no, I wouldn't mind that either, yeah.
So do we have a telephone number?
I'll get that to you.
This is my last question, last whatever. So, you do go through the steps and we contact the legal service and all that, and then the person find out that you contact the legal service concerning their situation, and they come and threaten you.
That's a whole different issue.
Yeah, that's a different problem.
You've got some wild fact No, we know it's a small world, and the idea is, generally we try to keep things quiet, and there's no reason to disclose the names of individuals who've raised concerns. I mean, sometimes, we might have to if there's a formal investigation or something, but generally speaking, if you come and talk to us, it's seeking initial advice, and we're not gonna go and say X person said so-and-so about them. And that's not how we operate.
But that does happen, so that's why I'm asking.
Yeah, I get it.
I have a question.
Yeah.
At the end of council meeting, you wanna direct the question to our individual persons that's sitting on that dais. Is that a conflict?
It's not a conflict.
So, but they're not.
The problem is that the city council is a body, so you address the body. Now, if you had something that you're talking about a council member, that there is a difference, but you do address the body. So you would be talking specifically to the city council, and then if you were saying, something happened, I don't know, I'm just gonna make this up. Councilman Smith did XYZ last week. What is the council doing about it? That's a different scenario than, Councilman Johnson, why aren't you doing XYZ? Councilman Johnson, get to it. Because then when you do that, then that's asking a specific council person something. So there's a difference.
And
there's no conflict.
You could say it, but they might not answer you, and they're not required.
They never do.
They never
So,
do.
in fact, I prefer if they don't, because no one wants to get to that.
They never do.
Especially if you got facts.
Yeah.
They never do.
Yes, ma'am.
And you said earlier about public, notice and being on your personal cell phone, if you receive something that is already public information and you kind of pass it on, does that,
It's not, you're not passing it on as your official role. I mean, if it's public, it's public, and it's not a record. I would just refrain from doing official business on your personal life.
do it on a?
Because you're just subjecting, you're just opening it up to discovery or a public record. Discovery's in litigation, so if someone sues you, or Public Records Act. I mean, just wanna try to segregate your worlds as much as possible. I know it's never easy.
There's a, that's almost sometimes we say that the city attorney represents the council and not the public. And from what I understand you're saying, no, you represent the city council and the public. However, the public can't come and ask you a question like what she was saying and get an answer for free directly that way. They would have to put some kind of notice out to you, and then maybe you might respond back that way, but you represent the public as well as the city council.
Well,
No, not
The
no,
necessarily.
not necessarily. I would say we represent the city, we're the legal counsel for the city, which is headed by the city council. And so we are responsible to the city council, to advising them. I can't give legal advice that would be binding, to any resident in the city, because I'm not their lawyer. In fact, I would probably tell them, I don't wanna give you legal advice, because, like, it's not my job, and like, But what I would typically do is, yes, we are responsive to the city council and the city as a whole.
That makes sense.
Yeah.
It's just the city council is the one who provides the direction because they're the body that has that authority. And so they generally are the ones who have the things that they direct to the city manager and vice versa. They want the stuff that's agendized, and so that's the stuff that is all set in the schedule. And so we discuss primarily everything with them, but when members of the public have things that are brought to our attention, we coordinate with the city manager and the city council to ensure that things get addressed.
So basically, you are kind of protecting the city. I mean, anyway, indirectly, by keeping the council and everything under control, making sure they're doing the right thing.
Yeah, I mean, we're not the police, so like, I always tell people, like, these are the rules, you choose whether you wanna follow them or not, but our job is to like, help you, like, outline what the rules are. But yeah, at the end of the day, we're here to advise and provide guidance to the city council and to city operations writ large on what the law says and how to do things. And also our job is to try to figure out how to do it legally to get to where they wanna go, right?
Well, the public sometimes always say, well, city attorney, he don't protect us, he protects them, and he's supposed to be protecting them and not protecting us in that sense.
Well, I mean, I think, yeah, it's like your city council are your elected representatives, and they're your voices, and and so they, our job is to, serve the city, and we receive direction and guidance and operate under the guidance of the council. I know that's
Any other questions we can answer about ethics, the Brown Act, or parliamentary procedure? That I know probably would be the most difficult one to answer questions about.
Could you give us can you give us, or everybody in general, when you're in a council meeting, and I'm gonna say it, the mayor tell you to get out, is that not supposed to be legal?
It is if the parliamentary procedure is not being followed. So if for instance, there's a topic that's being presented and people are like, for instance, somebody's talking and somebody else is interrupting, or they're going way over their time, that sort of thing, the mayor can actually order somebody to be removed.
or the chair,
Or the chair. By way of the sheriff, whoever's standing there. Usually in the city council meeting it's with the sheriff, but in the commission, I think usually they have some other staff member primarily there who can have somebody removed. It really depends. It's very rare that I've seen people removed, but it does happen, and it's not.
It happens a lot.
A lot of Tuesday.
It's not just in Compton that I've seen it happen. I will
More
say.
so there, but I'm in LA City too, and that doesn't happen at all.
But it does occur where, yes, they do have the authority to have people removed. So I'm just putting it out there that it does happen. It is within the authority of the city council, particularly the mayor, because that's the person who's in the seat, or the mayor pro tem when the mayor's not around.
They don't want to hear us telling the truth, that's all.
Well, it's about disrupting the meeting and not allowing the body to continue.
If you loud, but if you're whispering to your neighbor and then they looking at you and telling you, be quiet, I mean, that's like a bully move to me. If I'm talking to my neighbor, but why are you paying attention to me when you're supposed to be looking at the podium and speaking? That's the part I got.
Yeah. All right. Well, I know, Saturday morning you have better places to be. We're here, we'll stay here for a little while longer afterwards, but happy to talk individually, but thank you so much for all your time.